Welcome to the Lord's GA channel. Welcome to our 13th episode on the Law of Tort, Part 1. Today we are treating vicarious liability, that is the employer's duty to third parties. Let's begin by looking at what duties an employer owes to his employees. At common law, a master owes a duty of care to his workers. It is a personal one of a general nature. Lord Wright summed up the duty thus, quoted with approval by Owusu-Addo J. in Issa and Mim Timber in the leading case of Wilson and Clyde Coal Company Limited in English. A duty which rests on the employer and which is personal to the employer to take reasonable care for the safety of his workmen, whether the employer be an individual, a firm, or a company, and whether or not the employer takes any share in the conduct of the operations. The obligation is threefold: the provision of a competent staff of men, adequate material, and a proper system and effective supervision. The duty then is owed to each individual employee and therefore each workman's particular circumstances which are known or which ought to be known to the employer will determine the standard of care to be taken. But merely because one particular employee is likely to suffer greater pain does not impose a duty to take special care in respect of him on the employer, unless the operation on which the particular employee is engaged is in itself a dangerous one which needs special care. In Paris and Stepney Borough Council, for instance, a workman who had only one eye, as the defendants knew, was employed as a garage hand by the defendants. While working on the back axle of a vehicle, he struck a U-bolt with a hammer in order to facilitate its removal. A chip of metal flew off and injured his good eye. He was not wearing goggles and he claimed damages against the defendants on the grounds that they were negligent in failing to provide and require the use of goggles as part of a system of work. On appeal, Lord Normand held that as the operation in question was not in itself a dangerous one, the defendants were not obliged normally to provide goggles as part of the system of work, and that the plaintiff's disability was not relevant to the stringency of the duty owed him in that respect, because that disability exposed him not to a greater risk of injury, but only to a risk of greater injury. But the law does not require employers to dismiss employees if this is the only way of avoiding liability. See Withers and Perry Chain. Let's now use other cases to examine the three folds of duties highlighted above seriatim. First, provision of adequate and competent staff. See Black, Butler, and 5 Coal Company Limited. The House of Lords held the employer liable for this duty. In Hudson and Ridge Manufacturing Company Limited, Streetfield J. explained that it is the duty of employers for the safety of their employees to have reasonably safe plants find machinery. It is their duty to have premises which are similarly reasonably safe. It is their duty to have a reasonably safe system of work. It is their duty to employ reasonably competent fellow workmen. All of those duties exist at common law for the safety of the workmen, and if, for instance, it is found that a piece of plant or part of the premises is not reasonably safe, it is the duty of the employers to cure it, to make it safe, and to remove that source of danger. In the same way, if the system of working is found in practice to be beset with dangers, it is the duty of employers to evolve a reasonably safe system of working so as to obviate those dangers, and upon principle, it seems to me that if, in fact, a fellow workman is not merely incompetent, but by his habitual conduct is likely to prove a source of danger to his fellow employees, a duty lies fairly and squarely on the employers to remove that source of danger. The second is the provision of adequate tools and materials. See Davy and New Merton Board Mills. where Viscount Simmons held that it must then be shown wherein lay the want of reasonable care, and at once the question arises, for whose negligence acts, I suppose, of omission and commission, the employer is liable in the long chain which ends with the supply by him of a tool to his workman, but may begin with the delving of the raw material of manufacture in a distant continent. If a work involves special risks, the employer must provide protective materials, and a reasonable system should be set in place to see that they were used. In Clifford and Challen and Sons, for instance, although a protective cream was provided, the foreman of the defendants took no steps to ensure its use by the workmen. However, the court held that by failing to do this, the defendants were in breach of their duty to the plaintiff and were liable to him in damages. However, because of the plaintiff's contributory negligence, the amount of damages was to be borne equally by the parties. This is to be contrasted with Woods and Durable Suits Limited, where defendants did all that he was required to do for the safety of workers. However, plaintiff refused to use the cream. The third duty is safe system of work. In Speed and Thomas Swift and Co. Limited, the court identified 4 different features of any given system of work which should be considered by the employers. They include A. The physical layout of the job. B. The sequence in which work is carried out. C. The provision of warnings and notices of particular dangers, including special instructions when necessary. And D. The need to improve the system as necessary or modify it to deal with particular circumstances. In Kusasi and Ghana Cargo Handling, Sakode J. held that a master does not provide a safe system of work by merely providing a manual, especially to an illiterate workman, if no responsible person on behalf of the defendant supervised the workmen. The Kusasi case should be contrasted with the decision in Isa and Mim Timber, where Owusu Ado J. held that since the plaintiff had failed to prove that the system of work provided by the defendants was unsafe or that it exposed him to unnecessary risk, his claim in negligence would fail. Before concluding, let's look at the Labor Act 2003, Act 651, Section 9. Duties of employers states that, without prejudice to the provisions of this Act and any other enactments in a contract of employment or collective agreement, the duties of an employer include the duty to A. Provide work and appropriate raw materials, machinery, equipment, and tools. B. Pay the agreed remuneration at the time and place agreed on in the contract of employment or collective agreement, or by custom without a deduction, except deduction permitted by law or agreed between the employer and the worker. C. Take practicable steps to ensure that the worker is free from risk of personal injury or damage to health during and in the course of the worker's employment or while lawfully on the employer's premises. D. Develop the human resources by way of training and retraining the workers. E. Provide and ensure the operation of an adequate procedure for discipline of the workers. F. Furnish the worker with a copy of the worker's contract of employment. G. Keep open the channels of communication with the workers. And H. Protect the interests of the workers. Therefore, if you are solving a question on this area of law, remember to lay these 3 scope of duty together with the Labor Act to be able to ascertain which of the duty has been violated by the employer, if any. This is the end of our part 1 of this episode. Do well to join us for part 2. Please remember to subscribe, like, write your comments, and help share. Thank you.